All right, let's talk about one of the biggest, most exciting, and frankly, scariest financial steps you can take, buying a home with another person. Whether it's your partner, a friend, or a family member, that dream of co-ownership can turn into a legal nightmare really, really fast.
So let's just cut right to the chase, shall we? You've bought a home together. Things are going great. Until they're not. So what actually happens to the house if the relationship breaks down? It's a question that can turn a simple split into a total legal minefield.
To really get our heads around this, let's look at a real-world scenario. Meet Sydney and Samantha. They're an unmarried couple, and they did what so many couples do. They bought a house together to build their future. Sounds pretty normal, right?
Well, fast forward 8 years, and the relationship is over. And now they're staring down this huge, incredibly stressful question. How do they divide up their single biggest asset, their home? This is where the law gets involved. And trust me, it is almost never as simple as you'd think.
So, here's our roadmap for today. First, we're going to dig into the details of Sydney and Samantha's situation. Then, we'll explore the two main ways you can own property together. We'll look at what happens when your intentions aren't written down and how a court actually figures it all out. After that, we'll look at how you can change your type of ownership, and we'll finish up with the single most important thing you can do to protect yourself from the very start.
Okay, first things first, let's set the scene. The little details of how Sydney and Samantha bought their house are actually the key to unlocking this whole legal puzzle. Okay, so here are the facts. They bought the house for £500,000. The legal title, the official deed, is in both of their names. That £50,000 deposit, it was a gift to them as a couple from Samantha's mom. The mortgage was in both their names, and they paid it every month from a joint bank account. But here, and I mean here, is the kicker, the one little detail that causes all the problems. They never, not once, had a conversation about who owned what percentage of the house. So to untangle all this, we have got to understand a really fundamental idea in property law. And it's this. There aren't one, but two different layers of ownership for any property. And how they work together, well, that's everything.
We've got the legal title and the equitable title. The easiest way to think about it is this. The legal title is the paper ownership. It's whose name is on the deed, who has the power to manage or sell the place. The equitable title, on the other hand, is the value ownership. It's about who actually gets to enjoy the financial value of the property. Now, here's the crucial bit. The legal title can only ever be held as what's called a joint tenancy. But the equitable title, the real money part, can be held in two very, very different ways.
Let's break those two down. First, a joint tenancy. In this setup, all the co-owners are treated as a single legal unit. They own 100% of the property together. There are no separate shares. Then you have a tenancy in common. Here, each owner has their own distinct, separate share. It could be 50-50, 60-40, whatever they agree on. And this leads to this single most important difference: what happens if one of the owners dies? With a joint tenancy, this thing called the right of survivorship kicks in. It means the deceased person's interest automatically passes to the surviving owners. It doesn't even look at their will. But with a tenancy in common, your share is yours, and you can leave it to whoever you want in your will.
And this brings us right back to Sydney and Samantha. Because they never wrote anything down, the law has to step in and basically make an educated guess about what they intended to do with the value part of their ownership.
The law's default position is this little phrase, equity follows the law. And what that basically means is that the value ownership is presumed to be the same as the paper ownership. And since the paper title has to be a joint tenancy, the court's first assumption is that Sydney and Samantha also meant to share the value as joint tenants. In other words, the starting point is a 50-50 split.
But, and this is a big but, that's just a presumption. It's just the starting point. It can be challenged. One of them would have to prove that they actually shared a different common intention, that they had some kind of agreement, even an unspoken one, for something other than a 50-50 split, either when they first bought the place or maybe their intentions changed over time. So how on earth does a court figure out what a couple's common intention was when they never wrote it down? Well, it's kind of like being a detective, sifting through the evidence of their entire relationship to find clues.
So one way they can do this is the balance sheet approach. It's pretty much just cold hard math. A court would look at who paid for what. The deposit, that was a gift to both of them, so that's split down the middle. But that discount on the price, well, Sydney got that through his job, so a court might see that as a $10,000 cash contribution just from him. You add in the year he paid the mortgage all by himself, and if you're looking only at the numbers, you can make a pretty strong case that he contributed more and deserves a bigger slice of the pie.
But there's a totally different way to look at it, the family asset approach. This takes a much wider view. It looks at the entire course of dealings between them. The court considers their 8-year relationship, the fact they bought the place to be a family home, and that they pooled their finances for everything. And this is a really powerful point that courts are paying more attention to. This approach also values non-financial contributions, like Samantha taking unpaid time off work to care for their child. This perspective says, you know what, a family home is so much more than a spreadsheet. And it makes it far more likely that a court would decide their true intention was always to be equal partners, which points right back to a 50-50 split.
So we've seen how messy this can all get when intentions are vague. But what if you start out as joint tenants, and then, down the line, your intentions change? What if you decide you do want your share to go into your will and not automatically to the other owners? Well, there's a legal process for that.
For this, let's meet a new group, Amy, Bart, and Carla. They're 3 friends who bought a house together. Now, the key detail here is that when they bought it, they were very clear in the paperwork. They stated they would be beneficial joint tenants. That means they knew exactly what they were signing up for, owning it 100% together with that right of survivorship we talked about.
Now, the legal process for changing this is called severance. All severance does is convert a joint tenancy into a tenancy in common. It's the act of breaking that automatic right of survivorship and creating separate individual shares for each owner. Once you've done this, your share can now be passed on in your will.
So how do you do it? Well, there are 2 main ways. The first is called statutory notice. Basically, you give a formal written notice to the other owners that says you intend to sever your share effective immediately. The second way is through your actions. If you act in a way that treats your interest as separate, like say you try to sell or take out a mortgage on your share.
So, back to our story. Amy decides she's moving away and she wants to sever her interest. On her way to the city, she sends an email to Bart and Carla, and it seems like the wording is perfect. I am severing my beneficial interest with immediate effect. Sounds pretty straightforward, right? But here's the twist. The law that governs all of this, the Law of Property Act, was written way back in 1925, long before anyone had even dreamed of email. So the huge legal question is, does a modern form of communication like an email count as proper written notice under a law that's nearly a century old? And the answer, which might actually surprise you, is no. The courts have looked at this, and the general view is that an email probably doesn't count as valid notice under the 1925 Act. So tragically, when Amy dies in an accident later that same day, her attempt to sever has failed. The joint tenancy is still active, that right of survivorship kicks in, and her share automatically goes to Bart and Carla. Her best friend, who she'd named in her will to get her share of the house, gets absolutely nothing.
But wait, the story's not over. Sometime later, Carla needs some cash and decides to take out a mortgage against her interest in the house. This is a perfect example of that second way to sever, acting on your own share. By treating her interest as a separate, distinct asset that she could borrow money against, she legally and unilaterally severed the joint tenancy between herself and Bart.
And here is the result of that one action. The second Carla mortgaged her interest, the joint tenancy was broken. Instantly, she and Bart became tenants in common. Each of them now owned a distinct 50% share of the property. What that means is, if Carla were to die now, her 50% share would go to whoever she's named in her will. It would not automatically go to Bart. Her one action completely changed the entire legal status of their ownership.
Okay, so after walking through these 2 really different, really complicated stories, what is the big lesson here? How can you actually avoid all of this confusion and, let's be honest, potential heartache?
Well, it really boils down to this. First, you have to understand that the difference between a joint tenancy and a tenancy in common is absolutely critical, especially that whole right of survivorship thing. Second, if you don't have a written agreement, you're just leaving it up to a court to try and read your minds, and that is a massive gamble. And that brings us to the most important point. The absolute best way to protect everyone involved is with something called an express declaration of trust. It's a simple legal document you get drawn up when you buy the property, and it just clearly states who owns what. It takes all the guesswork out of the equation.
And that really just leaves us with one final question for you. If you own a property with someone else, do you know, for certain, how you own it? Are you joint tenants or tenants in common? After seeing what Sydney, Samantha, Amy, Bart, and Carla all went through, it might just be time to find out.